Yesterday, significant changes to the Privacy Act commenced operation, and it's very interesting to see that there's been many newspaper reports, from articles in The Australian yesterday to an excerpt on the PM radio station program on Monday night, to the effect that there's a mixed understanding across the business community as to what these changes actually mean. And in fact, privacy is quite a difficult concept to understand in practice, and I think that's the reason why many businesses don't realise what this is about. But in simple terms, the Privacy Commissioner from yesterday has very significant powers. He now has very similar powers to the powers of ASIC, and one of the most significant powers is that the Privacy Commissioner can impose penalties of up to $1.7 million for privacy breaches. Many people would have heard about Telstra's recent privacy breach, where thousands of names were published inadvertently and the fine was $10,000. But remember, that fine was under the old regime. Potentially, if the breach happened from yesterday onwards, the fine would be much more significant. I've also noticed there's a lot of confusion amongst commercial and consumer credit providers as to when they're caught and what their obligations are. Many credit providers are simply deciding that they won't get credit reports and then they can avoid the privacy obligations in relation to credit reporting. That's not the answer.
Andrea, you mentioned that there's radical changes to the consumer credit reporting. Who's going to be caught by these changes?
Basically, there's a lot of confusion about that as well in the marketplace. Many of our clients have assumed that you're only caught by those changes if you hold an Australian credit licence and you're providing regulated credit under the National Consumer Credit Protection Act. And regulated credit is credit for personal, domestic or household purposes or residential investments. So it includes things like loans for residential investment properties, I should say loans by individuals for residential investment properties, credit cards, home loans, personal loans, car loans. But in fact, yes, of course, anyone that holds an Australian credit licence providing credit, that is consumer credit, and they fall within the changes. But it also includes anyone that provides credit to individuals with payment terms of 7 days or longer. So that includes telephone companies for your mobile phone, energy companies for your electricity bill at home, gas companies for your gas services at home. Any of those people are caught. And as I've said earlier, that many credit providers think that if they simply don't get a credit report, then they can fall outside the new regime. That's not the case either.
And for those that haven't started their compliance?
It's never too late. This is not that suddenly yesterday was a drop dead date. The Privacy Commission has made clear that they will be looking at what organisations are doing. They want to see that organisations have made reasonable efforts to comply. So it's not too late to start. If you haven't already started, and it seems that the great percentage of the Australian marketplace may not have, get going now. Focus on the public-facing documents, the updated privacy policy, the new credit reporting policy you need to have if you're a credit provider, plus also your collection statements and notices. Anything that's public-facing on your website or appears to the public, focus on that first, get that sorted. But it's important that that documentation actually represents the information flows within an organisation, and that does require some degree of due diligence.
Some great tips. Thanks for joining us.
Thank you.